Friends, good morning. Today I am going to discuss with you one of the important judgment in which you will see that how the horring tale of large delay causes frustration in the mind of suitor who was deprived of his property. So I am talking about one of the important judgment of the Honorable Supreme Court of India, that is Ramesh Chand Ardhabatia versus Anil Panjwani. That is a older one judgment of 5th May 2003. What is covering all the parameters of the civil suit. You will not be left with any of the provision which has not been used in the judgment. So the present list, having attained the age of 15 years by this time, this is observed by the Honorable Supreme Court, is one horring tale of laws, delays causing frustration in the mind of a suitor who was deprived of his property and who rushed promptly to the court for vindicating his rights and seeking protection under the arm of law. He faced adjournments and adjournments without any substantial progress at the trial in an overcrowded, overburdened trial courts, that is at the lowest rung of the judicial hierarchy, and was unable to, which is a trial court which is unable to spare such time as the individual cases demand, so as to have a firm grip over the progress of each case. Several revisions taken to the High Court at interlocutory stages of the trial too contributed to the delay, adding fuel to the fire of the plaintiff's agony. The record of tarding proceedings in the trial court, at least at the initial stage, reflects the defendant's impunity. He felt that he is beyond the reach of law, though fortunately such hope of the defendant proved to be only a nightmare. The case is Anil Panjwani, the plaintiff, filed a suit styled as a suit for declaration, possession, and permanent injunction against Ramesh Chand Ardhabatia. The plaint was presented on 9th February 1987 in the Court of Additional Munsif, Class 1, Jaipur City, West Jaipur. The suit property is plot number 2, measuring area 273.03 square yards, described by boundaries, that is 61 and a half on one side and 40 on another side. Briefly stated, the gist of the plaint affirmance is that on 1st December 1985, Panjwali entered into an agreement for purchase of the suit property for a consideration of rupees 4,500 from one Shri Nivas Vaidya, who was the owner of the suit property. A document in writing was executed. Rupee 4,000 were paid and rupee 5,000 were to be paid at the time of registration. Original documents relating to the title of the vendor were passed on to the Panjwali. On the date of agreement, the plot was lying vacant, and in December 1985, Panjwali constructed a boundary wall, desirous of raising construction on the plot in the near future. But on 8th February 1987, at about 4 p.m., when Panjwali had gone to inspect the plot, he found a mason raising a hutment and two women sitting there. So he was confused. On making inquiries, Panjwali learnt that some construction was proposed to be raised at the behest of Arti Bhatia. Neither on that day nor on the following day Arti Bhatia Arda Bhatia could be found out by the Panjwali. So he filed the suit. This suit was filed on 9th of February 1987 for the following reliefs. First was declaration of plaintiff's title as owner of the suit property. Second was restoration of possession from the trespasser to the plaintiff. Third one was mandatory injunction for removal of the construction raised by the trespasser. Fourth one was permanent prohibitory injunction from raising any further construction. And fifth one was costs. And sixth, he prayed that such other reliefs as the court may deem fit and proper in the facts and circumstances of the case, and to which the plaintiff may be found entitled. The day on which the plaint was presented, it appears that the presiding judge was on leave, and so the matter came to be placed before an in charge judge, maybe as per the rule or practice prevalent in the state of Rajasthan. On an application filed by the plaintiff, he directed one Shri Pratap Singh advocate to be appointed as an advocate commissioner to visit the suit property and submit a report as to the factual status thereof. The Land Advocate Commissioner visited the site of dispute from 6 to 7 p.m. on 9th February 1987 itself. The plaintiff Panjwali and his advocate were present along with 4 to 5 persons on the plot, of whom one was male and other were females. They refused to interact with the commissioner. Rather, they threatened the visitors that their heads will be broken if they entered into the plot. The neighbors present apprised the Advocate Commissioner that a house was proposed to be constructed on the plot. The Advocate Commissioner too formed the same impression by his inspection and evaluation of the site. One advocate, Mr. Mahendra Singh Baghela, unconnected with any of the parties and a resident of that locality, happened to be present there. The most material part of the Commissioner's report is a sketch map according to which the plot was an open place of land whereon in the northwest corner there was a hut. Some pieces of stone, of bricks, and a heap of sand were lying in different parts of the plot. There was a butter tip also. The plot was surrounded by a boundary wall. The persons present on the plot and the neighbors who had assembled there refused to sign on the report of the commissioner, though requested to do so. The plaintiff Panjwani, his advocate Shri Ramnath Sharma, and advocate Shri Mahendra Singh, present at the site, subscribed to the report. What is significant to note in the commissioner report is that there was no construction at the site, and certainly there was no house and no habitation, much less any person or family having been found as residing in any manner on the plot. The grass hut was apparently for use by the laborers. And on 10th February 1987, the defendant appeared in the court through his counsel. However, the presiding officer was on leave. Though the defendant was served with summons in the suit as also with notice on the prayer for the grant of ad interim injunction, no written statement or reply was filed on 10th February 87. The presiding officer was on leave this day also. The matter was placed before a judge in charge. He directed status quo as to the suit property to be maintained, restraining the defendant not to proceed with any construction. Thereafter, on 15 dates of hearing, the matter was simply adjourned without the defendant having filed any written statement or reply. On 24th February 1987, the plaintiff moved a second application for appointment of yet another commissioner to carry out inspection of the suit property in the presence of both the parties. It appears that the purpose of appointment of the second commissioner was to have a bi-party inspection carried out as the inspection carried out on 9th February 87 by Shri Pratap Singh Advocate Commissioner was in the absence of defendant, and there was some element of urgency involved in the inspection on that day, so as to bring on the record of the court the status of property on the date of institution of suit. Now Shri S.K. Kataria, advocate now appointed as Advocate Commissioner, carried out inspection of the suit property on 25th February 87 in the presence of plaintiff and a representative of the defendant, probably his special power of attorney holders. Shri Kataria also drew up a sketch of the suit plot incorporated in his report. The identity of the plot is same, but with a little change as to its status. Building material consisting of bricks, sand, and stone were lying on the plot. In the northwest corner, instead of the hut, a temporary kitchen made of bare bricks had come up, and in the northeast corner, covering an area of 6 by 12 feet, two small rooms and a platform had come up, which were newly constructed. The report drawn up by the commissioner bears the signature of the plaintiff and a representative of the defendant. Here itself, we may observe that the second report by the Advocate Commissioner, the correctness whereof has not been disputed by the defendant any stage of the proceeding, is prima facie suggestive of two inferences. Firstly, that even till the date of bi-party inspection carried out by the Advocate Commissioner, the plot was vacant piece of land on which construction had just commenced and was in the process of coming up. And secondly, the defendant had proceeded with construction work in spite of interim order of the court directing status quo as to the suit property to be maintained and specifically restraining the defendant from proceeding with the construction act. On 4th June 88, under the administrative order of district judge, the case came to be transferred to the court of an additional judge. Therefore, the case was adjourned on 29 dates of hearing again without the filing of written statement or reply. At least on 3 dates of hearing, the defendant was allowed adjournment on payment of costs of rupee 40, rupee 50 and rupee 250. On 29 October 92, the defendant and his counsel absented from appearance in court. The case proceeded ex parte. On 24th July 93, the date appointed for the plaintiff's ex parte evidence, the defendant filed an application under Order 9, Rule 7 of the CPC, seeking setting aside of ex parte proceeding. And on 6th September 93, the case came to be transferred to another court under the administrative order of the district judge. On 11th May 94, the trial court passed a detailed order holding that the defendant has completely failed in assigning any good cause for his previous non-appearance. Therefore, his application under Order 9, Rule 7 of the CPC was liable to be dismissed. So it was dismissed accordingly. The plaintiff examined three witnesses in ex parte evidence, including himself and his vendor. Though such as ex parte evidence was recorded piecemeal on at least three dates of hearing, the defendant or his counsel were not present and did not participate in the proceeding. The arguments of the counsel for the plaintiff were heard and judgment was reserved. In between, the defendant had preferred a civil revision, laying challenge to the order dated 11th May 94. While order dated 20th March 95, the civil revision filed by the defendant was directed to be dismissed by the High Court. And on 25th March 95, the defendant moved an application labeled as one under Order 18, Rule 17 of the CPC, submitting that the defendant has not cross-examined the plaintiff witness because of pendency of his civil revision in the High Court, and as the civil revision was dismissed, he may be given opportunity of cross-examining the plaintiff witnesses. And on 2nd May 95, the court allowed the defendant's application subject to payment of costs and subject to the term that before the cross-examination is commenced, the plaintiff will have a right, if he so desires, to put to his witnesses additional questions by way of examination in chief. Now, at this stage, the genuinity of the defendant appellant came into play. On 2nd May 95, he moved an application proposing to place on record a written statement under Order 8, Rule 6A of CPC. It was alleged therein that the plaintiff was claiming the suit premises under an agreement dated 1st December 85 entered into by Sri Nivash Vaidya based on letter of allotment dated 26th June 80 issued by the Cooperative Society Limited, which letter of allotment is false and forth, and therefore it has become necessary to have declared the letter of allotment dated 26th June 80 and agreement dated 1st December 85 null and void. Copy of the application seeking leave of the court to file a written statement by way of counterclaim and accompanying counterclaim were delivered to the plaintiff counsel, calling upon him to file a reply. While the above proceedings were going on in the trial court, the order dated 2nd May 95 was put in issue by the plaintiff Panjwali by filing a civil revision in the High Court. The by order dated 16th January 96, the revision was allowed. The order dated 2nd May 95 was set aside. However, the High Court directed the President and Secretary of the Society, which has allotted the plot, to be examined as court witnesses along with the relative records of the Society. The marathon race began between the court and society. The court was seeking production of the record so as to enable recording of the statements of the office bearer of the society as court witnesses to comply with the direction of High Court. several past officers of the society and their successor, as they were ascertainable, were summoned one after the other. None admitted the availability of record with him, and each one went on passing on the buck to other. The office bearer of the cooperative department and the administrator appointed in supersession of the society were also summoned, but the records were just not traceable. At the end, on 21st December 2000, after making a reference to the High Court soliciting direction, the trial court held that the direction earlier made by the High Court was not possible of compliance for want of record. The evidence was closed as permitted by the High Court in its order dated 11th October 2000, responding to the reference, also directing the case to be decided within 3 months in view of the previous delay. The arguments were heard. At this stage, the defendant moved an application seeking leave of the court for examining his witness. In view of the peculiar facts and circumstances of the case, especially the fact that the application was highly belated and that too in the background of event that his application under Order 9, Rule 7 of the CPC was rejected up to High Court and his counterclaim was not taken on record, the court by order dated 4th November 2000 turned down the defendant's prayer for production of his evidence. The order dated 4th November 2002, whereby the court had refused the defendant an opportunity of producing evidence, was put in issue by the defendant by filing a revision in the High Court. The defendant failed to produce any order of stay from the High Court. The trial court noticed in its order dated 21st December 2000 the previous order High Court dated 11th October 2000, whereby the High Court had directed the case to be disposed of within a period of 3 months, which time limit was coming to an end. By judgment and decree dated 8th January 2001, the trial court directed the suit filed by the plaintiff to be decreed. The plaintiff was declared owner of the suit plot and defendant was directed to restore possession of the plot within a period of 1 month from the date of decree, failing which the plaintiff would be entitled to have the encroachment and illegal construction, whatever be of the defendant, to be demolished and removed at the cost of the defendant. Against this judgment, the defendant preferred first appeal and he also preferred a first appeal against the decree dated 8th January 2001, which was registered as first appeal number 3 of 2001. It was heard and dismissed by the 5th Additional Judge Jaipur by judgment and decree dated 7th March 2001. The defendant preferred second appeal, which was also dismissed on 16th April 2001 by the High Court, forming an opinion that appeal did not involve any substantial question of law within the meaning of Section 100 of the CPC. An application under Order 41, Rule 27 of the CPC, filed by the defendant before the First Appellate Court seeking production of certain documents by way of additional evidence was rejected by the First Appellate Court as in its opinion no case for admission of additional evidence was made out. The High Court found no fault with the view so taken by the learned additional judge. So this SLP by the defendant has been filed on 28th April 2001. On 16th July 2001, a two-judge bench of this court directed notice in SLP to be issued. On that day, the plaintiff Panjwadi Bani too was present in person, having filed a caveat opposing the special petition. The court allowed him time to file counter affidavit and ordered the status quo as of that day to continue. The learned senior counsel for the appellant had made several submissions which can be grouped into three. First one was that the civil court did not have jurisdiction to try the suit and the plaintiff should have been relegated by the trial court to pursue his remedy before the authority tribunal competent to adjudicate upon such disputes under the provision of the Rajasthan Cooperative Society Act 1965. Second was that even if the defendant was being proceeded ex parte, his counterclaim should have been taken on record and heard and decided on merits. Failure to do so has occasioned a failure of justice. And third, that even in the proceeding ex partes against the defendant, the plaintiff was not entitled to the decrees as prayed for. The Honorable Supreme Court said, we find, as will be dealt with hereinafter, the first two pleas devoid of any merit, but partial merit in the last plea. As to the first submission, we find that the civil court does not suffer from any inherent lack of jurisdiction. Where there is a special tribunal conferred with jurisdiction or exclusive jurisdiction to try a particular class of cases, even then the civil court can entertain a civil suit of that class on availability of few grounds. And exclusion of jurisdiction of civil court is not to be readily inferred. This is the case law of Dulab Bhai versus State of Madhya Pradesh and another of 1963. An objection as to the exclusion of civil court jurisdiction for availability of alternative form should be taken before the trial court and at the earliest, failing which the higher court may refuse to entertain the plea in the absence of proof of prejudice. Now, what is the Section 75 and Section 137 of the Rajasthan Cooperative Society Act 1965 provide? Now, first is Section 75, which says disputes which may be referred to arbitration. Notwithstanding anything contained in any law for the time being in force, if any dispute touching the constitution, management, or the business of cooperative society arises among members, past members, and persons claiming through members, past members, and deceased members, or between a member, past member, or person claiming through a member, past member, or deceased member, and the society, its committee, or any officer, agent, or employee of the society, or between the society or its committee and any past committee, any officer, agent, or employee, or any past officer, past agent, or past employee, or the nominee, here or legal representative of any deceased officer, deceased agent, or deceased employee of the society, or between the society and any other cooperative society, or between the society and the surety of the member, past member, deceased member, or a person other than a member who has been granted a loan by the society or with whom the society has or had transaction under section 66, whether such a surety is or is not a member of society. Such dispute shall be referred to the registrar for decision, and no court shall have jurisdiction to entertain any suit or other proceeding in respect of such a dispute. Now, for the purpose of subsection 1, the following shall be deemed to be disputes touching the constitution, management, or business of the cooperative society, namely a claim by the society for any debt or demand due to it from a member or the nominee here or legal representative of the deceased member, whether such debt or demand be admitted or not. A claim by the surety against the principal debtor, whether the society has recovered from the surety any amount in respect of any debt or demand due to it from the principal debtor as a result of the default of the principal debtor, whether such a debt or demand is admitted or not. Any dispute arising in connection with the election of any officer of the society. If any question arises whether a dispute referred to the registrar under this section is a dispute touching the constitution, management, or the business of the cooperative society, the decision thereon, the registrar shall be final and shall not be called in question in any court. Now coming to section 137, bar of jurisdiction of courts. Save as provided in this act, no civil or revenue court shall have any jurisdiction in respect of the registration of cooperative society or of an amendment of any bylaw, the removal of the committee, any dispute required under section 75 to be referred to the registrar, and while a cooperative society is being wound up, no suit or other legal proceeding relating to the business of such a society shall be proceeded with or instituted against the liquidator as such or against the society or any member thereof, except by the leave of the registrar and subject to such terms as he may impose, save as provided in this act, no order, decision, or award made under this act shall be questioned in any court on any ground whatsoever. So, in the present case, there is nothing to show that the defendant is also a member of the society or claiming under a member. The plaintiff does not have any dispute with another member of the society or the society itself. The question of jurisdiction is to be determined primarily on the averments made in the plaint. The plaint, as framed by the plaintiff, is for declaration of title as owner, and in the alternative, his possessory title, and seeking restoration of possession, as also issuance of mandatory and preventive injunctions against a recent encroachment. Neither is it a dispute between the parties referred to in clause A to E of subsection 1 of section 75, nor does the nature of the dispute falls in clause A to C of subsection 2 of section 75, so as to be one excluded from the domain of civil court. At no stage of proceeding has the dependent appellant taken any objection to the jurisdiction of the civil court to try the suit. So we are not satisfied even prima facie to hold that the civil court suffered from any jurisdiction incompetence to hear and try the suit. Several revision petitions were preferred in the High Court, engaged the orders passed at several stages of the proceedings of trial court. An objection to the jurisdiction of the trial court was not taken before the High Court in any of the civil revisions. It will be too late in the day to permit such an objection being taken and urged at the hearing before this court. The plea as to want of jurisdiction in the trial court is devoid of any merit and is therefore rejected. Now, as to the second submission, placing strong reliance on two decisions of this court. First one is Mahendra Kumar and another versus State of Madhya Pradesh and another, and Shanti Rani Das Devanji versus Dinesh Chandra De. The Land Senior Counsel for the appellant submitted that it is permissible to prefer a counterclaim even subsequent to the filing of the written statement, and trial court was therefore not justified in refusing to take cognizance of the counterclaim filed by the defendant and to try it on merits solely on the ground that the case had proceeded ex parte and counterclaim was sought to be pleaded bilaterally without a written statement being on record placed by the defendant. The land, the Land Senior Counsel for the appellant submitted that although the defendant appellant had not filed a written statement and though the case was proceeded ex parte against him, still, if the defendant had filed a counterclaim admissible and entertainable within the meaning of Order 7, Rule 6A of the CPC, it ought to have been entertained and tried, and failure to do so has occasioned an irreparable prejudice to the defendant appellant. Order 7, 8, Rule 6A does not provide for any stage for county filing a counterclaim, and assuming that there was a delay, that the loss of time could be compensated for by awarding a suitable cost. But the counterclaim should not have been refused to be entertained and tried and submitted the learned senior counsel. He prayed that at least leave which should be allowed to the appellant is to direct the counterclaim being taken on record and entire case then remanded to the trial court for hearing and decision afresh in the light of counterclaim filed by the defendant appellant. Order 8 of the CPC deals with written statement, set off, and counterclaim. We would like to state, by way of clarification, that the provisions of the CPC which are being considered herein are as amended by Act 104 of 1976 only, excluding from consideration the amendments incorporated by the Act of 46 of 99 with effect from 1st July 2002. According to Rule 1 of Order 8, the defendant shall, at or before the first hearing or within such time as the court may permit, present a written statement of his defense. Under Rule 2, the defendant must raise by his pleading all matters which show the suit not to be maintainable, and all such grounds of defense as if not raised would be likely to take the opposite party by surprise. Under Rule 6, the defendant may, at the first hearing of the suit, but not afterwards, unless permitted by court, present a written statement containing the particulars of the debt sought to be set off, subject to certain limitations. Rules 6A, 6B, 6C, introduced by the Amendment Act 1976, reads as under. Now, first 6A, subclause 1. A defendant in a suit may, in addition to his right of pleading, a set off under Rule 6, set up by way of contract claim against the claim of plaintiff any right respect of a cause of action occurring to the defendant against the plaintiff either before or after the filing of the suit, but before the defendant has delivered his defense of before the time limited for delivering his defense has expired, whether such counterclaim is in the nature of claim for damages or not, provided that such a counterclaim shall not exceed the pecuniary limit of jurisdiction of the court. And second supply says such counterclaim shall have the same effect as a cross suit so as to enable the court to pronounce a final judgment in the same suit, both on the original claim and on the counterclaim. Third one is the plaintiff shall be at liberty to file a written statement in answer to the counterclaim of the defendant within such period as may be fixed by court. The counterclaim shall be treated as a plaint and governed by the rules applicable to the plaints. 6b says, where any defendant seek to rely upon any ground as supporting of a right of a counterclaim, shall in his statement state specifically that he does so by way of counterclaim. 6c. Where a defendant sets up a counterclaim and plaintiff contends that the claim they raise ought not to be disposed of by way of counterclaim, but in an independent suit, the plaintiff may, at any time before issues are settled in relation to counterclaim, apply to the court for an order that such a counterclaim may be excluded, and court may, on the hearing of such application, make such order. I think fit. So, under Rule 8, any ground of defense which has arisen after the institution of suit or the presentation of written statement claiming a setup or counterclaim may be raised by the defendant or plaintiff as the case may be in his written statement. Under Rule 9, no pleading subsequent to the written statement of the defendant other than by way of defense to set up or counterclaim shall be presented except by the leave of the court and upon such terms as the court thinks fit. But the court may at any time require a written statement or additional written statement from any of the parties and fix a time for presenting the same. So, a perusal of the above said provision shows that it is the Amendment Act of 1976 which has conferred a statutory right on the defendant to file a counterclaim. The relevant words of the rule 6A are: a defendant in a suit may, in addition to his right of pleading, a set off under Rule 6, before the defendant has delivered or before the time limit for delivery of defense has expired. These words go to show that a pleading by a counterclaim runs with the right of filing of a written statement, and that such right to set up a counterclaim is in addition to the right of pleading a set off confirmed by under Rule 6. A set off has to be pleaded in the written statement. The counterclaim must necessarily find its place in the written statement. Once the right of the defendant to file the written statement has been lost or the time limit limited for delivery of defense has expired, then neither the written statement can be filed as of right nor a counterclaim can be allowed to be raised for the counterclaim under Rule 6A must find its place in the written statement. The court has a discretion to permit a written statement being filed bilaterally and therefore has a discretion also to permit a written statement containing a plea in the nature of set-off or counterclaim being filed bilaterally. What needless to say, such a discretion shall be exercised in a reasonable manner, keeping in view all the facts and circumstances of the case, including the conduct of the defendant and the fact whether a belated leave of the court would cause prejudice to the plaintiff or take away a vested right which has accrued to the plaintiff by lapse of time. So, in the and the court said the appeal filed by the defendant is partially allowed. The degree of declaration that the plaintiff respondent is owner of the suit property is set aside. Instead, it is declared that from 1st December 85 to 8th February 87, the plaintiff was in peaceful possession of the suit plot pursuant to agreement dated 1st December 85 entered into by Shri Nivas Vedya, the allotee of the plot from the society in favor of the plaintiff. The plaintiff is also entitled for mandatory and permanent preventive injunction. It is ordered and decreed that the construction, if any, raised by the defendant on the plot and hutment raised by his laborer shall be removed by him and possession of the plot shall be restored to the plaintiff. The defendant is permanently restrained from interfering with the possession of the plaintiff over the suit plot except by due process law. The suit filed by the plaintiff shall be deemed to have been decreed by the trial court in the above said terms. The trial court shall draw up a decree consistency with the judgment. The cost shall be borne by the defendant appellant up to the High Court level, and the costs in this court shall be borne as incurred. So, going by the judgment, the time taken to reach up to this final orders, that was more than 15 years. And even the original complainant lost his temper to this ups and downs in the delays in the proceedings of the trial court. But the Honorable Supreme Court taken light view after warning. The judgment was given, and in which, if we go by the first line, the appeal filed by the defendant is partially allowed. And other direction was given that the trial court will decide the title again. So again trial will go on for few years. So I mean to say, or the Honorable Supreme Court mean to say, they required some checks at the trial court level so that the unnecessary adjournments are not given and there is speedy trial. No doubt trial courts are overburdened, but keeping in view the flaws in the system, revisions, orders, and revision get interlocutory orders, and this way this process lingers on, and people are losing faith due to not timely decision of the case. So that is all about what I to say. Thank you for watching.